Stephanie Dobson is back with us again this week. Stephanie is a lawyer and mediator at Hanka Divorce Law and Mediation here in Lloydminster. This is another episode of Healthy, Thriving Families in Two Homes. So Stephanie, a lot of our conversations revolve around mediation, and today we're going to dig into that a little bit more. Let's remind the viewers exactly what mediation is.
Yes, absolutely. So our viewers have heard lots about negotiation process, and mediation is one of them that I do quite often. And so mediation is a negotiation process for families who are experiencing conflict or who are separating or divorcing or who basically have something to work out between them. So a mediator is a neutral facilitator, or otherwise known as a process manager, that helps the parties to feel heard, to bridge the gaps between the two parties, and to help them to resolve conflict and reach resolution on whatever topics they need to talk about. So the focus on mediation is to try to find a mutually acceptable resolution for the parties. So it can be broken down into 4 easy steps. So the first is an initial consultation, which allows me as the mediator to get to know the parties and find out their story and understand better what's going on for them. Number 2 is a series of joint meetings. So some people need 2 meetings, some need 5 meetings, but a series of meetings where we talk through and resolve all of their conflict. Then next, at the end of that, the mediator will draft some kind of a document, whether it's a separation agreement or a summary, to express what those outcomes of mediation is. And then at the end, ultimately, the parties will typically look to hire an independent legal advice lawyer to help them to sign off on their separation agreement or their whatever the document is that we end up creating.
Now, you mentioned, Stephanie, that the parties involved often get lawyers, but is this something that they have to do? Is it mandatory to get a lawyer?
You know, this is a question that families ask me all the time, because a lot of times the reason that people are coming to mediation is to have the negotiations be held by them directly, as opposed to negotiating through lawyers. However, I always recommend that parties get independent legal advice at the end or even throughout the mediation, but there's never a have to. It all comes down to how comfortable the parties are with respect to coming to their own agreements without independent legal advice. So the role of a lawyer and the role of a mediator is very different. So as I said before, the role of a mediator is to be neutral and to help the parties to reach their own resolution within the context of legal information and the foundations that the law creates for us. Now, the role of a lawyer is to be an advocate, to negotiate on your behalf, and to be your voice, to help you to know and understand your legal rights and obligations under the law. So sometimes the lawyers can actually come into the mediation process, and we can do that in a few ways. Sometimes parties will want to leave their lawyer in what I call in the background, which means that you may hire your lawyer, you formally retain them, and if you have questions as you go through the mediation process, you can talk to them in between sessions, you can talk to them just at the beginning, and at the end, you have that flexibility. Other times, there are parties who feel more comfortable having their lawyer at the table with them. So essentially, that becomes a 5-way meeting. So we've got 2 spouses, we've got 2 lawyers, plus the mediator. So obviously, that starts to get a little bit more expensive, but the most important thing as you go through mediation is to make sure that you feel very comfortable as the separating spouse or the spouse going through mediation, that you feel really comfortable in attending and voicing your concerns or your thoughts.
If one party decides not to get a lawyer and there is a mediation agreement, is that binding, or what exactly does that mean for people who don't have lawyers in this process?
You know, this is the best answer I can give is it depends. So it really depends on the comfort level of the parties in reaching their own resolution without having their lawyer involved or their lawyer sign off. And it also depends on the content of the agreements or the topics of the agreements that have been reached. So let's first start with parenting related issues. So there's no legal obligation that on two parents that a lawyer sign off on a parenting arrangement. So trying to figure out a schedule, decision-making responsibilities, even child support. There's no obligation that a lawyer sign off on that. Now let's talk about spousal support issues. This gets a little bit more tricky because I always recommend that you get a lawyer to sign off on your spousal support agreement, because that is, if you reach agreement and then later on you have regret about that agreement, if you didn't get a lawyer's signature, there is a chance that that agreement could get opened back up by the courts. Lastly, division of your assets and debts. There is specific legislation that says you must get a lawyer's signature to sign off on this in order to make this legally binding. Now, there are some, if you're, for example, if you're refinancing a house as part of a separation or divorce, there might be a bank obligation on you to have a lawyer's signature, not just your own signatures on a separation agreement. So there's different reasons why you would actually need a lawyer to sign off on that. But as I always say, I always recommend that you seek independent legal advice before, during, or after your mediation.
All right, Stephanie. Well, thank you for joining us once again, and we'll be back to chat with you next week.
Thanks, Stacey.